In this video, we will look at section 124 and section 125 of the Indian Contract Act 1872. Section 124 defines the contract of indemnity. What is the contract of indemnity? According to section 124, a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called a contract of indemnity. So a contract of indemnity is nothing but a contract wherein one party promises to save the other party from any loss caused to him. How is that loss caused? Either by the conduct of the promiser himself or by the conduct of any other person. We look at these two terms, one the indemnifier and second the indemnity holder or the indemnified. The indemnifier is the person who gives the indemnity, while the indemnity holder or the indemnified is the person for whose protection the indemnity is given. Let's look at the illustration given under section 124. You have three entities out here, A, B and C. A being the indemnifier, B being the indemnity holder and C being a third party. So, in this illustration, A contracts to indemnify B against the consequences of any proceedings which C may take against whom? Against B, in respect of a certain sum of money. This is known as a contract of indemnity. Section 125 talks about the right of the indemnity holder when he is sued. So, when the indemnity holder is sued, he can recover from the indemnifier or the promiser what? Number one, all damages in respect of any suit which he may be compelled to pay. Now, the suit cannot be any suit under the sun. It will be a suit in respect of any matter to which the promise to indemnify applies. Section 125 subsection 2 states that the indemnity holder will be entitled to seek from the indemnity giver or the indemnifier all costs which he shall be compelled to pay in any suit, whether bringing it or defending it, wherein he who the indemnity holder did not contravene the orders of the indemnifier and acted as it would have been prudent for him to act in the absence of any contract of indemnity, or if the promiser himself authorized the promisee, or in this case the indemnity holder, to bring or to defend the suit. Section 125(3) states that the indemnity holder shall be entitled to recover from the indemnifier all sums which he may have paid under the terms of any compromise. Remember, the first two sections talked about a suit. This third subsection talks about a compromise. So any sum which he may have paid in terms of a compromise to the suit, if the compromise was not contrary to the orders given by the indemnifier or the promiser, and which was one it would have been prudent for the promisee to make in the absence of any contract of indemnity, or the indemnifier or the promiser himself authorized the promisee to compromise the suit. Let's look at the case of Vishan, Narain versus Oriental Insurance Company Limited. Now, in this case, Vishan Narain had taken out an insurance policy on his vehicle, a Maruti van, for rupees 1 lakh with the Oriental Insurance Company Limited. Now, during the period of insurance, the van was stolen and it was not recovered, and it became a total loss. Now, Vishan approached Oriental Insurance for rupees 1 lakh and other damages. but the insurance company was willing to give only rupees 70,000. Matter went to court. The court held that the insurer was not permitted to say that his liability was only up to the market value of the vehicle, and thus the court held that Vishan was entitled to the insured sum of rupees 1 lakh plus damages.